you.
Mr. Knox, I'm sorry you were detained by technological glitches.
It's not the first time I've been detained. Anyway.
What are glitches?
My lords, my lady, the answer, as best I can give to the question I was asked before lunch is this. The revenue does exercise autonomy and does not take instructions from the government as to who to investigate or who to sue for tax. Secondly, assessments in the past have been raised on government agencies. There's nothing unusual, in other words, in the notion of the government, or rather the revenue, seeking to raise tax or chase government agencies. And there is nothing on file, the revenues file, to suggest that the assessment in this case was made as against Mr. Monteil rather than on CL Financial, because, as is suggested, the government was a major shareholder in CL Financial. The point that's put against us is, well, we went for Mr. Monteil because the government's a major shareholder in CL Financial. Ergo, that is all unfair. Now, my lords, I do also add this. This point about why did the government go for Mr. Monteil as opposed to CL Financial wasn't one that was raised at all below. I've certainly seen nothing in the papers to that effect. And instructions from my jury who was appearing in Trinidad below confirms that. So it wasn't a case, and it wasn't suggested, therefore, that there's some sort of underhand motive for going against Mr. Monteil. And therefore, I do respectfully submit that particular point. One understands the point. That particular point is not a point which really can concern your lordships on this appeal.
Are you able to help us? Is there a control mechanism, do you happen to know, as to when the revenue goes for the employer, when it goes for the employee? Can it go for both? What governs that?
I'm not...
You don't know?
I don't know.
No, all right.
I am instructed, though, that in this particular case, the appellant was selected for investigation on a random basis. So he wasn't targeted as such.
Yes,
And
okay.
it seems that he was first informed that he was being investigated in November 2011.
Yeah, but at all events, you say it hasn't been raised, but it hasn't been investigated locally at all.
And my lords, my lady, I think I can concede that if there was some sort of targeting in an unfair way of an employee, when really the government should be going, let's say, against a company in which it happens to have a big shareholding interest, well, that might, I just say might, give grounds for judicial review. But that's not before you in this case, and it hasn't been raised in the past. Can I just, first of all, just make a few general points on the law? And there are 3 points I'd like to make. First, I do submit that whatever doubts may be expressed over some of what Lord Donovan said in Mangin at 861 and 867 to 868 of the bundle, there can be no doubt as to the general principle that unless there is statute is clear and unambiguous, one should seek to avoid wholly absurd results or absurd results. And not only is there the Mangin case to that effect, but also my Lord Hodges' judgment recently in the bundle, which we do have. I think it's the case of R.O., the Secretary of State for the Home Department, at page 898, paragraph 30. Secondly, as a matter of general principle, my submission, although you construe charging provisions strictly against the Crown, you don't do so. You don't apply that same strict test in relation to machinery provisions, which are there in order to enable the charging provisions to be given effect. And if I can ask you, please look at a convenient summary of the position in the Trinidadian case called PRV IT Commissioner at 920, about halfway down the page.
920?
920, halfway down the page. This is the judgment, first instance, which it went to appeal, and the Court of Appeal said it was a very learned judgment and said the judge got to the right conclusion by the wrong route. But that doesn't matter for present purposes, because the judge does go through an awful lot of tax cases about how to construe judgments. That would be as things stood, I think I might be saying, in the late 1950s. But the passage I want to take you to begins about halfway down the page, on page 920. It is of some importance to distinguish those sections which operate the first of Lord Dunedin's three stages, that is, those that impose tax liability in generally designed charging sections, and those which enact the remaining two stages, namely assessment and quantification, and collection, which are usually termed machinery sections. Although the same principles of construction apply to both charging and machinery sections, the method of their application is slightly different. Thus, in Hennell, Lord Hanworth said, it has for a number of years been an unbroken rule of the courts that where there is a charging section or charging act, the meaning of which is in doubt, it will be construed the subject. But then in Lippman and Barron, Lord Justice Cohen held that this rule did not apply to a provision giving taxpayer relief, that is a machinery provision, from a charging section which clearly imposed liability. And then again in Whitley, Lord Dunedin said, my lords, I shall now permit myself a general observation. Once that is fixed that there is liability, it is antecedently highly improbable that the statute should not go on to make that liability effective. The statute is designed to be workable, and the interpretation thereof by a court should be to secure that object, unless crucial omission in clear direction makes that end unattainable. And I do particularly rely upon that in this case, because I submit on the face of it, there's no doubt whatsoever that there is a charge imposed, or chargeability imposed on the taxpayer, and one would therefore need clear provisions to show that that was not intended to take effect simply because of Section 99. And I say such provisions don't exist. The third point I would like to make on the cases is on the Unilever case. The first point, it doesn't appear, at least so far as I can tell, that the problem arose because of limitation. It doesn't, in the case itself, no point appears, at least, to have been taken on limitation. It may be, if one goes to page 966, it may be limitation or perceived limitation problems where the background to it, I should show you that, page 966. Paragraph 2, you can see Unilever in 2004 and 2005 provided for some of its employees a motor vehicle and so forth. And then it looks as if...
Sorry, just before
Yes.
we get to there, paragraph 1 sets out the issue, which,
Yes.
I think if one reads this, it's clear that it was all about whether it's a precondition for operating the Section 99 machinery that you have, first of all, to have issued an assessment.
Exactly, yes. I'm grateful, my lord, yes. That was the issue. The reason I think there may possibly be some limitation point lurking in the background is because of what you see in paragraph 2, the income years in question 2004 and 2005, and then paragraph 8, the notice of determination issued on 14th November 2011, and so on. So that maybe that's what my learned friend is referring to when he says there was a limitation issue in the background. Well, my lord, my lady, all I can say about that is that doesn't appear to have been what concerned the Court of Appeal in that case, and perhaps the point wasn't taken, as maybe it could have been, for all I know, that the employer couldn't be sued in relation to chargeability in the employee, where the limitation already expired against the employee. That point doesn't appear to have been taken. Maybe it could have been, we don't know. The other point I want to make about Unilever is that it is clear from everything it says that the premise on which the judgment proceeds is that there are two ways of recovering in an employment situation. That is, first, you can either sue the employee direct, or you can go against the employer. And can I just briefly run through it? If I can just take you briefly, I'm not going to read the passages out, but to the relevant passages. The first is at 968. Findings and conclusion. I think my learned friend took you to this, but it's 14A to 14C, but in particular 14C. And then page 970, you can see the same thing again. Therefore, under the para 19, Therefore, under the pay-as-you-earn provisions of the Income Tax Act, an employer can be directly liable for tax on unpaid loss in employees' emoluments on the basis of its own separate statutory liability.
Sorry, which paragraph was that?
19.
19, thank you.
Separate, in other words. The whole premise is there's two ways of going. And then 49, para 49 at 975. Sorry, paragraph 29 at 975. Separately enforceable.
Sorry, which paragraph?
29, 975. At page 980, paragraph 49, the Court of Appeal explains what, in their assessment, the phrase notwithstanding any provision to the contrary in section 99 means. Paragraph 49. At the beginning. They say section 79, 6 and 7, an example of where there's a divergence. And then paragraph 50, page 981. Last sentence of the citation. And then, finally, page 989, paragraph 89, and you'll note in particular 89C, findings and conclusions. I would respectfully submit that it's quite plain that the Court of Appeal here is moving on the premise that the employee is liable, and indeed the revenue can look to the employee to make the payment, instead of, if appropriate at least, the employer. There's one other point I would like to make. It's on a case raised by my learned friend in his case called Guyana Beverages. A decision, I think, well, I'm not sure which Caribbean court it is, but it's page 780. And just my learned friend referred to a passage at 786.
And what's the reference in his case? All right, don't worry. Don't worry.
But my learned friend refers to this as a case where the Commissioner General had made an assessment, and one of the questions, if you go to page 785, you'll see paragraph 13, section 70, subsection 1, the Commissioner General may proceed to assess to every person chargeable with tax as soon as may be, after the day prescribed, and so forth. And he may, and you'll note similar wording to section 83 in our case, where a person has delivered a return, the Commissioner General may A, accept the return and make an assessment, or B, refuse to accept it, and to the best of his judgment determine the chargeable amount. And then paragraph 7, the Commissioner General indicates how he treats with these matters, and he says, I will contend that pursuant to section 70, subsection 2 of the Act, I acted as follows. And he accepted some returns and rejected others. And then the court goes on to say, paragraph 17, this court found that the Commissioner General's affidavit made it clear that he was not treating with the delivery of documents to the Guyana Revenue Authority. Paragraph 7 makes clear that he was performing a statutory duty under section 70, subsection 2 of the Act. It follows, therefore, that acting under section 70, subsection 2, the Commissioner General could not make adjustments to the returns for the years of assessment, years of income, which, according to his affidavit, he accepted. Now, my learned friend relies on that. He says, right, once you've accepted something under section 83.2, that's it. But the important point is what is said next. The decision of the court below is therefore reversed on this ground. The Commissioner General must assess the returns for that period as presented and accepted by him unless there is some lawful basis for changing an assessment initially found on the, quote, accepted returns. Then, in paragraphs 20 to 22, they go on to say, well, there was a power under section 72 of the relevant act in that case to make additional assessments, in other words, an equivalent to section 89. And they go on to say, well, of course, the Commissioner General was entitled to go back on his assessment under 83.2 by the additional assessment route. And that, my lords, is that you can see that essentially at paragraphs 20 to section 20, paragraph 22. Page 788. So I say here, even though it is said that the revenue accepted the assessment of the appellant initially, the revenue was entitled to go back on that by virtue of the additional assessment provision. The other case I would like to go to is what was said by Lord Rembury in Whitney. My learned friend took to that.
If one looks at the opening words of section 89, there is an assessment which is being re-examined.
Yes, but my lord, there it is. I thought I ought to show you that.
Oh yes, thank you.
It's a point, a case my learned friend relied on, and it is clear, I say, from the opening words. The other point is the Whitney case, which my learned friend took you to in the speech of Lord Rembury at page 1012, because I submit that when you read on the passage he took you to, it's against rather than for him. Can I ask you please to go to page 1012? It begins at halfway to the third paragraph down, section 7, subsection 1 is self-contained and imperative. My lords, my lady, the problem in this case was that the revenue wanted to surcharge a US citizen, I think, wanted to impose a super tax on an American citizen who was in America. And the question was, what mechanism, if any, could the revenue use to get him? And the question was what did he have to do in order to enable the revenue to impose a super tax on him? And if you read from section 1012, section 7, the paragraph beginning section 7, over the page, my lord, I rather suggest that is against my learned friend's contention as to what's being said here.
So where are we to read from?
It's the third paragraph down,
yes.
Section 7, subsection 1. And if you read to the end of the page, just going over the page, which is pretty well the end of the judgment. Taken in that case, which there's a minority, there was a three. The point taken by the minority was it's a bit unfair to suppose that the relevant tax act was seeking to impose on an American, a US citizen, an obligation to notify, even though he's in America, to notify the revenue. Or rather serve the relevant notice. And so they said, well, the provision for serving a notice can't apply, therefore he can't be liable. In other words, the machinery can't be said to operate in this case, which the majority said, well, he is liable, and if he doesn't operate the machinery just because he's an American who doesn't know the law, bad luck, basically what they said. But the point I rely on here is that if there is a liability, and if on the proper view there is a liability, it's not an answer to say there may be a problem with the machinery in enforcing that liability. There may be issues about what the machinery is. My lords, my lady, I now turn to my first submission, which is the absurdity point. And I do respectfully submit that there is no real answer to it. What it means is this. An employee can keep sums, indeed large sums, paid to him, which should have been paid to the revenue by way of tax by the employer, and nonetheless the revenue has no direct recourse against him for the return of those monies, even though they're sitting in his bank account, say, for example, and they're large sums. And in my submission, I do submit that on the face of it, this would apply. The revenue would not be able to get or touch or make an application against the taxpayer direct, even if he should have known, negligent, even if he should have realised that deductions weren't being made. On my learned friend's case, there's nothing the revenue could do. In my respectful submission also, even if, let's say, he was entirely innocent, but nonetheless he's sitting on large sums of money, which plainly he shouldn't have once it's drawn to his attention, he'd be entitled to say to the revenue, oh, I do see your point, but you know what, you can't come against me directly. I submit that's entirely implausible. And it would seem he could do so even if, in the meantime, the employer had become insolvent, and when I say insolvent, I mean with no money, or if he was employed by an individual or partnership, the people who employed him had simply disappeared. I submit that it is fanciful to suppose that the Tax Act intended any such point. I do also submit, although I don't have to go this far, that it would appear to mean that even if the taxpayer has acted in bad faith in somehow getting the monies into his hands, that is to say the tax monies into his hands, it is not an answer to say, look at section 119 and 121(2) of the Act. I would accept that section 119 does appear to be drafted in fairly wide terms to catch pretty well everyone, but one has to look at section 121(2). And that, in my suspicion, is a point which was raised, I'm not saying raised with approval, but raised by Lord Briggs. If you look at section 121(2), the premise of that appears to be...
Page?
Sorry, 494.
Sorry, 121(2).
Yeah.
Sorry?
Yes.
121(2).
Yeah, the point I raised. Yeah.
Yes. The problem with that is if one starts from the premise that the employee has no liability to pay, how can section 121 subsection 2 bite on him? No doubt he can be sent to prison, or whatever else it is, maybe impose a big fine on him. But this, in my submission, is not a natural way of getting the tax monies that the employee owes into the revenue's hands. A fine, of course, won't go to the revenue. I submit, even if, in the case of fraud, it is not clear, and certainly not...
When you say this is not a charging provision, refers to something as being taxed, and it has to be taxed under some different provision.
Yeah.
Well, it could be. It says any tax. I think my learned friend's case would be, well, that way any tax covers tax which was payable by the employer, which my answer is, well, if he's not liable, ex hypothesi, not liable to pay tax, it's not easy to see why you could get him under section 121, subsection 2. But, my Lord, even if one says the point is debatable, that's no way of drafting statute. It's a surprising way to draft a statute, to leave the point unclear in that way, if my learned friend is right. Next, my learned friend refers to section 99, subsection 4, at page 475. But, my lords, my lady, you've seen this before. The operative words are really those in the last 5 lines or so. In other words, this is a provision directed towards employers who don't make the necessary deductions or payments to the revenue. The employer is guilty of an offence in such a case. That's the final words. He is liable to pay as if the tax was payable by such person, which must be by the employer, on the date when the amount was required to be deducted. So it is presupposing in one sense that he's not normally to be treated as exactly subject to the normal provisions for collection, but if he doesn't comply with his duties, then he will be subject to the usual provisions relating to collection. But in my submission, this doesn't begin to answer what you might call the absurdity point. My learned friend says, well, section 111 subsection 2 provides for the problem of the insolvent employer. And section 111 is at 484, going over the page. There's the requirement that you must pay within 30 days, and if you don't, then the revenue can make out a certificate saying what is payable, and then subsection 2. On production thereof to the registrar of the Supreme Court, a certificate made under this section shall be registered by him in the High Court, and when so registered shall have the same force and effect as a judgment. So it's a speedy way of getting a judgment, essentially. In my submission, this doesn't take one anywhere. At the moment, I'm not aware, I cannot say, that there's any special provision that judgments owed to the state take priority in an insolvency. But in my submission, there are other points in any event. First of all, there is an insolvency provision in the Act, and that's section 99, subsection 5, but it's a limited insolvency provision. That is at page 475. Can I just ask you to read subsection 5 to yourselves, beginning all amounts deducted?
Yes.
My lords, you can probably guess the point I'm going to make, namely there is a provision for, as it were, certain sums or certain things to be held on trust. That is to say, if the employer, as it were, pays the employee $1,000 and keeps back $300, and the $300 he's holding on trust.
A very odd kind of trust. I mean, in ordinary daily life, the employer doesn't sort of assemble a pile of sovereigns and pay over 2/3 of the pile to the taxpayer and keep 1/3 back.
No.
It just pays over an amount representing 2/3. So to what does the trust attach?
Well, then it
out of
may
an
well
overdrawn
be
account.
have been paid out of an overdraft.
Yes.
Yeah.
So there may be nothing.
Yeah.
There may be nothing, but the point is there is a limited provision in relation to...
Yes.
Yes, sure, and that must be what it's for.
Yeah, that's what it's for. But if you have, as we allege in this situation, there's no question of any deduction being made. It's just the whole lot is paid over to the employee. There's no equivalent provision there that says the employer, as it were, is deemed to be holding that part which he should have deducted on trust. It's only what he holds on trust is that which he has deducted.
Yes, it does say whether or not they have in fact been kept separate and apart from such person's own money. So, I mean, it's difficult to speculate how this would actually operate in practice, I must say.
Yeah.
But yes, in other words, it's saying it doesn't matter if you haven't put them in a separate account.
It does, yes.
That's all
But
it
if
is.
you're just operating on an overdraft, then it's hard to see
But
how it works at all.
you must be able to tell whether it's been deducted
Yes.
because you look at the employee's payslip.
Yeah.
And that's what then absolves him of the liabilities we saw under section 9910.
Yes.
Oh, yes.
Yes.
As a matter of mathematics.
Yeah, but that doesn't follow that there's going to be an asset
It's a
there
sort of,
to which
it's a
trust
sort of
duty is going to
floating
attach.
trust, I think,
Well,
which will attach to anything that happens to be available.
but the one thing that isn't held in trust is the monies which are paid over to the employee. He's not holding them on trust.
Yes, there's no deeming provision that which the company has paid out or its equivalent is to be held in trust in the company's bank account.
And that's the only point I'm seeking to make. The other point I make is, in any event, I'm still on the absurdity point. The real problem is that the employer could well have gone into insolvency. I mean, when it's insolvency, without any money, very little money, nowhere near enough to satisfy the liability. And it does seem, in my respectful submission, odd to say that even in those, that the Act, even on a strict view, the Act even precludes the employer, the revenue going after the employee in that case, when the employee's got the money and has received it. And let's say, for the sake of example, hasn't changed his position on the faith of some representation. But there are, of course, one can imagine all sorts of different situations in which the problem might arise, but of course, that isn't before you at the moment. I mean, I should say, in the before the Tax Appeal Board, they said there is no estoppel here. I mean, one can imagine, perhaps there might be cases when the revenue might conceivably be stopped, or one might say it's totally unfair for the revenue to go after the employee. And one can imagine some such situations. Let's say the employer has absolutely no idea. As far as he's concerned, he's got the money, but what's actually happened is the employer has not deducted.
It may not be money, that's the thing. It may be
benefits in kind.
Benefits in kind, which perhaps everyone assumed were not taxable, and then suddenly there's a decision that they are taxable. But he's eaten the lunches or driven or consumed the petrol or whatever. He hasn't got the money in his bank.
Yes. Well, the difficulty is we're not in that situation. And
well, we don't know what the benefit in kind here was.
No, but on the preliminary issue, you are not. You don't have those.
But I think what you're saying is that if there is a situation where it's actually very unfair to expect an employee to come up with money when he's not actually had money, then there are other ways that can be tempered.
Dealing with it, yeah. And there is a process by which the employer and the revenue are supposed to operate. And you can see that it's the actual process which is supposed to be operated. If you go to section 99, I'm just going on a little ahead for the moment, but 473, you can see the process by which, or this is the start, which tells you the process by which deductions are to be made. And it's just 99 itself at the foot of 473.
Sorry, where is the process?
And then the process is set out in the employment regulations.
Oh, you mean it's just a reference to the regs?
Yes. Yeah, it's the reference to the regs in section, and then the relevant regulations, the relevant parts of the regulation of first 554, basically it sets out the timing at which deductions are to be made, how it's all supposed to be operated by the employer, and obviously in such a way that the revenue knows what's going on. So first of all, you have regulation 4.
So which page are you on now?
554, forgive me.
Thank you.
And then subsection 2 provides for certain unusual situations where the revenue is to tell employers what tax to deduct. This is more general background. I'll come to the specific mechanism. Page 557 is regulation 8, which my learned friend took you to. And my lords, my lady, I respectfully submit regulation 8. One can see what's going on. This is essentially, while the employment relationship is continuing, this is providing for how is it to be operated. It's not really talking about assessments or additional assessments made years after the event. But then regulation 9, payment of tax deducted. And this is when the payment is made. So the revenue will know whether or not the employer is doing what he ought to be doing. Regulations 9 and 10. The reason I mention this is that the revenue will know whether or not, as the year goes on, as the months go on, whether or not the employer is complying with his duties. So one could posit an extreme case when the employer simply doesn't pay over a penny, as he should do, to the revenue, let's say over the course of an entire year, and the employee has no idea that this is happening. He's just getting what he supposes to be his post-tax income. Turns out that actually the employer hasn't accounted for hasn't paid over anything to the revenue. Well, one could well imagine in those circumstances, the obvious point made against the revenue would be, well, as far as I was concerned, I had absolutely no idea that tax wasn't being paid over to you. And you had every opportunity of finding that out.
But if the deduction's been made from the employee's wages, he was pro tanto discharged from his tax liability.
Well, that would be another
option. Very
yes.
clearly.
Yes.
9910.
Yeah, it's 1910.
Well, when you say you could make this point, it's all terribly unfair, in what context could he make that point?
Well, if he said, if the revenue said, you still owe lots of tax because monies weren't properly deducted in accordance with proper calculations, then he might be able to say, well, you should have realised that. You can't come after me now. I didn't. It was your job, if you like, to police the PAYE system.
But isn't that
and you
what
didn't do
this-
that.
Isn't that what Mr. Monteil is saying?
Well, it is, but one can see in certain situations that the employee would have a case for saying it's totally unfair that I'm now being asked to pay this tax because I genuinely had no idea that deductions weren't being made. I don't, as I understand the case that is before you at the moment, don't understand it being said that he had no idea, certainly on the revenues position, it's not being said. We certainly don't accept that deductions were made. In other words, our position is all these sums were just paid over to you. At the moment, the question of whether or not deductions were made is not before the courts at all.
Yes, if they were made, it's quite clear that would be a defence for him because he'd be discharged.
Yeah, you might well be able to say that.
Yes, 9910 tells us so.
Yes.
I mean, we are presumably working on the basis that the employer told Mr. Monteil that his earnings were X.
Yes.
And that appears in the tax return, but the earnings you say were more than X because it included hefty commissions paid into a particular bank account.
So, yes.
Yes.
But anyway, I thought I'd show you that just so one understands that there would be things one might say to the revenue in certain types of case, because it obviously is their job. Well, they have the ability to see what's going on simply because they're meant to be receiving monthly statements.
But that would just be a factual background to us, an estoppel claim.
Exactly, or unfairness claim. My lords, my lady, I now want to come to my next submission, which is the scheme of the Act. And we set this out in our case. But we say that the scheme of the Act presupposes throughout that the employee retains a liability to pay sums which have been paid to him, which should have been paid to the revenue. Can I deal with the sections outside Section 99 first? And first of all, Section 76 at 452. Section 76(1) uses the phrase every person liable to furnish a return and so forth shall furnish a return in the form approved by the board, and it's got to be signed by him under subsection 2. But under subsection 4 on page 452, notwithstanding subsection 3, an individual who is resident in Trinidad and Tobago whose sole source of income is from an office or employment, then or not resident, then shall be relieved of the obligation of furnishing a return of income under subsection 1. And one then goes to one then goes to section 77, which is at 454. Notwithstanding section 76(4, the board may, by notice, require any person or so forth to make returns under the Act. Now, what appears to have happened here is that Mr. Monteil did actually make a return, because we've seen that. I think my learned friend might be right. I think, as I understand him, it's saying that it's not necessarily the case that every employee does provide a return, but he can be asked to provide a return. And in this case, he was asked to provide a return.
Do we know that?
Sorry?
Do we know he was asked to provide a return?
Oh, my lord, I don't know if he was asked. You're quite right. We know that he did provide one.
Yes, quite.
Yes, I think that's as far as you can go on the facts.
And as to those who don't provide a return, the scheme is essentially that you go to section 98. E provides section 98, collection and recovery of tax. The employee...
Just before we leave
Yes.
76, is your point that the relief of someone who is only getting income from an employment in 4A is necessary because otherwise he would probably be a person, quotes, liable to pay tax under this Act, under 3A?
Sorry, you'd be liable, yes.
Pay tax under 3A, subsection 3A.
Yes. Yes.
Yes.
Yes, it is an exception to subsection 3.
Yeah.
And as to employees who don't file returns, or employees generally, what they are meant to do is you go to page 472, section 98. I'll just ask you to read section 98.1. He tells the employer what allowances he wants to claim, so the employer can work out what his eventual bill should be.
And this is a stage of bringing about the employer's certificate.
Yes. And then you go to the regulations at page 562, regulation 20.
So he would say in this jurisdiction, for example, I make these payments to charities, so I'm entitled to a higher
Yes.
basic allowance.
And then the employer then sorts that out for him. 562. Regulation 20, the declaration which a person, that is the employee, may file under section 98 may include allowable deductions.
But why does any of that assume personal liability of the employee to pay the tax?
No, it doesn't. I'm just explaining that there is a difference between the employee who puts in a return and other employees who, it seems, don't put in a return, and all they do is they write to their employer saying, I want these allowances.
These are my deductions.
And then the employer sorts it out for them.
Yes, and instead of a tax return from the employee,
Yes,
there's an employer's certificate which will list the emoluments and the deductions. Yes.
Well, so I was just showing as well the different ways it works. Here we are in the first situation where there's a return that's actually been made with a declaration.
Yes.
And then the regulation 12, I think, 558, it provides for the employer's certificate. But the important point here is a return has been made with the declaration. And then section 79, page 456, and I submit this is important for the reasons which have already been gone through. Can I just start mentioning this point? Section 79, subject to this person, you'll see the phrase every person. Again, this phrase every person crops up quite a bit in these provisions. Every person shall pay to the board on the quarterly dates the relevant amount of tax on his income as estimated. But then, I should say 79.2, you assume you're going to have the same income as the last year, unless you say otherwise. But then section 79.5, if I can just ask you to read that yourselves. I found it difficult myself to understand it at first, but I think that was just me. And page 457.
Right, yeah. I mean, if he's got non-employment income, then it's that should be. He should account for tax at the highest rate applicable to his total income.
Exactly. You treat the non-employment income, you add it
as
and then
being
say,
a top slice.
top slice.
Yes.
So that's but here, an important point I want to make about all of these, they are all talking about employees. In other words, sections outside section 99 are all positing particular situations relating to employees, which makes it unlikely section 99 is what you might call a complete and comprehensive code, is woven into all these other provisions rather than excluding these other provisions. Then you have section 99(6), which caters for the position where the employee receives income both from his employment and from his dividends or other properties. And then section 99(7). But you'll note, I should say, in each of 5 and 6 and 7, you have this notion, well, sorry, 6 and 7, the employee is to pay to the board the remainder of his tax for the year as estimated by my lord, my lady. Questions were asked of my learned friend, and I submit there's simply no answer to the point that the premise of this is that he is liable to pay tax on what hasn't yet been paid. And that is a general liability, in my submission, to pay income tax where he has not so far paid the right amount because his estimate was wrong. It cannot be the case, realistically, that you can make a subjective estimate, which let's say is honest, but totally wrong, and then say, well, I made my estimate under section 79(7), you know. It was an honest estimate, it was completely wrong, and therefore there's no liability. The premise is there is a liability which survives the end of the year, if you like, and he's got to pay whatever is left.
So the actual liability is not substituted with the estimate once he puts it.
Put another way, yes, it's the actual liability is not extinguished by the underestimate. And this section, in my submission, presupposes an obligation remains on him, generally, to pay whatever outstanding income tax there is on his income.
I mean, these provisions seem designed to require him to pay insofar as there isn't going to be any dispute because it's in line with his own estimate.
Yes.
And then it sets a timetable, so pay quickly, in effect.
Yes. Well, pay before the 30th of April, I think. Yes. It's like a sort of catch-up provision. But the fact that you pay what you think you owe for the catch-up provision doesn't mean actually there's not rather a lot more that you have to pay. And you have the same set of provisions in section 80. I just mentioned it, section 85 and 80 subsection 6 in relation to the year 1963. I don't think anything turns on it. My learned friend said in relation to this provision, he said, well, you have to look at this in the light of Regulation 24, which is at page 564. But in my submission, one doesn't really get very much out of this. 564, Regulation 24(1) is the provision which requires the employee to refund any amounts which are too high because the wrong amount's been deducted.
Is it the board refunding the employee?
Yes.
24(1).
Sorry, 24(1) is the board refunding the employee.
And 24(2) is the employer getting money from the employee.
Yes. But that, yes, the employer then gets it from the employee. The point about 24 subsection 2 is the employee is the one who's liable.
I'm struggling to imagine an employee who would complain to the board in that situation.
Well, he might, because he might be. The point was raised. Why would he ever do that? Well, one possibility is he doesn't want to get in trouble with the revenue because he is personally liable to pay and interest would run on late payment.
So the whole background to PAYE, which is that when people have money in their pocket, they tend to spend it, even if they know that they ought to be saving it.
Yes.
But I mean, if he's worried he hasn't paid enough tax, and on your submission that none of this is derogates from his own personal liability to pay tax that hasn't been deducted, why don't you just pay the tax to the revenue?
Well, he might want it properly sorted out through. He might have more than one employer. He might want it properly sorted out through his employer, rather than having to deal with the revenue himself.
He might. It's just the curious assumption that firstly he complains to the board, and then the board goes to the employer and apparently says, now you must deduct some more. Right.
Yes. Well, I agree.
So who do you read the he in the third line from the bottom as referring to then?
He would be as I understand it, be the employer.
Yes, because in the previous paragraph, when they want to refer to the board, they call it the board.
Yes.
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 Yes, I only suggested earlier this morning he must be the misprint for the board, because we couldn't understand why it should go through the employer.
Oh, well, there are reasons. I agree. Not everyone thinks of them all day long, but there would be reasons where you may think, I just want to get my tax affairs sorted out. Not enough tax is being
Or
taken off.
perhaps the revenue will agree an instalment programme, provided that they know that they're not relying on him to pay it every month, but will get it deducted from his salary.
It may, as much as anything else, simply be a sort of a provision to mirror Section 24.1, Regulation 24.1. You cater for both situations, although in real life, 24.1 is the one that matters.
Well, quite.
Yes. And these provisions, you say, and I understand the submission, are all pointing to a continuing liability on the employee taxpayer.
Yes, that's the premise on which the regulations are drafted. And there's another, a similar provision, Regulation 4, while I'm on the regulations, page 554. Regulation 4.
Which page?
554. I may have taken it before a moment ago. Subject to various sub-regulations, every person paying emoluments to an employee or the holder of an office shall deduct or withhold therefrom on account of the tax payable by the employee, and so forth. Such amount. So I submit that Section 79, that there's no real answer to the point about Section 79.6.
And the matter becomes abundantly clear when you get to 99.3 and 99.10.
99.3 and 10. But can I just mention, before I get there, I'm conscious of time, I don't want to weary the Lordships with endless provisions from the Act. But Section 81, can I just draw your attention to this? Every person shall, in 30 days, pay to the board that. Now, there are no exceptions, unlike in Section 79, which says subject to the following and so forth. Section 81 would appear to be applicable to everyone.
That's page
549. 459.
459.
459.
But that assumes he gets a notice to pay.
He gets a notice to pay, but once he gets a notice to pay, every person who gets a notice to pay must pay. And that will certainly include employees who file returns.
Well, no, not everybody. Every person who gets a notice to pay must pay.
Yes.
It doesn't imply that every person gets a notice to pay. I mean, an employee whose 100% of whose income is coming from his employer is unlikely to get a notice to pay.
Yes, exactly. I agree. But if he does, and that's why I submit it is quite important that this is a case where a return was made. But I submit 81 would apply to the appellant in this case.
I mean,
there's no exception.
Mr. Knox, if you just would chart the course through the sections applicable to the appellant.
Well, that would be applicable.
Well, I mean,
in the first instance.
we start with there is a return. We've seen the return. We know that it's initially accepted by the revenue. But the revenue then has another look because it does an audit on a random basis. So just take us through the applicable sections, as it were, chronologically. That, I think, would help me.
Well, 81 would be.
Well, that presupposes a notice of assessment has been, so there must be something before
you need
that.
89.1 to bring in 81, don't you?
Or 83.1, I think, in the first place, at full
Well, I would also, like Lord Richards, really appreciate if you would say, okay, they do this audit, they say, goodness, there seems to be a lot of tax that's not been paid here. What's their next step then?
Well, the first step is 83.1 and 2, because I think it is accepted that a person has delivered the return, and that is the appellant.
And where is...
460, 83.1, and then 2, where a person has delivered a return. The board may accept the return and so forth. And my learned friend says may is permissive, as if that's somehow not...
I mean, it does actually, because what happened was, as I understand it, that the appellant did deliver a return and the revenue accepted it.
Exactly.
So end of story as far as 83 is concerned.
Exactly.
Yes,
End of
okay.
story.
So we've done all that. So we've now done the audit. More money is apparently, there's more income. So where we go to 89.
89.
Yeah.
And that's the all-important section.
Yeah.
Yes, it's 89 that triggers off the action here.
Where it appears to the board that any person liable to tax has not been assessed or has been assessed at less amount than that which ought to have been charged.
Yes,
Or met.
so the random investigation triggers 89.
And my lords, my lady, we say that is what the answer to this whole case is. And it not only does it trigger the assessment, but section 89.1 also authorises a demand for payment.
The final words of that subsection.
And we say that's it.
Yeah.
Subject, unless the whole thing is excluded by section 99. And we say there's no basis for saying that.
Sorry, the closing words of 89.1, did you say?
Closing words of 89.1.
The provisions of this Act as to ... other proceedings under this Act shall apply
yes.
to the assessment and to the tax charged thereunder, which takes you back to 81.1.
Yeah.
Well, doesn't it take you to 86? Does it take you straight back to, because it says the provisions of the Act as to notice of assessment, etc., shall apply. So we have to go to a provision dealing with the notice of assessment.
And rights of appeal. You're quite right. First you go to 86, which is notice of assessment, rights of appeal. Yeah. But it also, by the wide words, includes the right to make a demand for payment, which is in 81.
Well, hold on. I just wanted to do it chronologically. So it's 89, and then 86.
86,
is it?
yes.
Well, strictly speaking, it should be 85, I suppose, isn't it? Because 86 applies where you've got a list, an assessment list.
Yes.
Is that right?
Yes, and you have to be on the list.
You have to be on the list, so nothing is to be missed. And then there's a notice served under 86, and then that leads to 81. Is that yes. Now, just this may seem a curious question, but section 89.1 says that where it appears to the board that, quote, any person liable to tax has not been assessed.
Yes.
Where do we find that the appellant is liable to tax in respect of his income, his earning, his emolument?
Well, I think that would probably have to go back to section 81. Well, section 81.1, every person shall within 30 days from the day...
No, there must be some basic charging provision.
I mean, one expects it in section 5, and
Yes.
I'm not sure it's probably implicit in section 5.
Oh, I see. You mean, well, I think section 5 is the underlying charging provision of all people.
Yes.
Yes, income, reading short, income tax shall
355.
be payable. Yeah.
Yes, my lord, I apologise. That is, it must be the answer, shall be payable upon the income of any person accruing in.
I mean, it's implicit that it must be that person who is liable.
Yes, yes. Whether received what own respect of, and so on and so forth. And I think the relevant provisions for employment is over the page, I think.
Is there actually?
Schedule E, isn't it? Gains 5(1)E.
Yes, yes. Emoluments,
Yeah.
that's section 100.
Where-
So he's caught by that.
Page 356.
Although I don't want to go through, but that is how it essentially works, we say.
Yes.
We also say that if you go past section 99, and we set this out in our case, if you go past section 99, and I'm just looking at paragraphs 35 to 41 of our case, we set out all the other provisions after section 99, which obviously operate on the premise that that there's no exception for employees. It's everyone. So, for instance, employees can be sued in the magistrate's court if there's a small debt. How come? If
Section
111, I believe, 112. And perhaps I can just give that as a very clear example.
yes.
Maybe it's 110.
It's page.
And that, I think, is at page 483. 483 to 484. And in particular, you get that from 110 subsection 3.
Yes.
Now, I might
Say,
have,
well, what's the point of that if he's not liable for tax on that?
I mean, he'd just say, well, I'm terribly sorry, I don't quite understand why I'm here in the first place. The premise of this is he's not paid the right amount of tax for whatever reason. He has not properly paid tax, or he's filled in a wrong return, but that more tax can be recovered from him direct. But my lords, my lady, all these provisions, if you go from 109 onwards, there's no exception, if I can put it that way, for the employee. And the revenue can take whatever steps are necessary, whether by garnishee orders, effectively trying to stop someone leave the jurisdiction, that's section 109 if they owe tax. There are an awful lot of enforcement provisions which on the face of it are plainly applicable to employees. And we say, why not? There's nothing that leads one to suppose that employees are exempt from the provisions you see at 109 to 112. That's perhaps the simplest way of putting it. But my lord, my lady, we settled this out in our case. I don't see it through Boris.
Getting back to 99.3 and 99.10, 99.3 deems that which is deducted to have been received, and then which presumably is designed to create a potential liability on the employee.
Yes.
And 99.10 says, but if there is deduction, he ceases to be liable.
But, and importantly, my lord, at the time of the payment, because if you look at 99.3, I'm now moving to 475, subject to subsection 10, where an amount to be deducted and withheld from the emoluments, it shall, for the purpose of this act, be deemed to have been received by such person at the time of the deduction. Now, I submit that's important because, of course, interest is chargeable on late payments. Indeed, penalties are chargeable on late payments. So it's important that he's deemed to have received it as at whatever the relevant date is. And then, subsection 10, you'll note the word thereupon. Subsection 10. So what I submit is all presupposing that he does have a liability.
Isn't 1993 to deal with, he might otherwise complain that he's not been paid his contractual salary if he gets less in his pay packet. So that's
well-
saying, well, if the reason why you get less is that it's been deducted, you're treated as having received it, and that makes up your gross salary.
Well, yes, but I would submit this goes in particular to his liability, or rather liabilities to the revenue, as opposed to as were arguments which might arise as between the employer and the employee. It shall, for the purpose of this Act, be deemed to have been received by such person at the time of the deduction. So he's taken to have received it at a particular time.
Receive what? The amount deducted?
Yes.
Well, yes, yes.
But at the same time, if there has been a deduction, he ceases to be liable for tax on that to the extent of the deduction.
Exactly, yes.
Yes.
And I submit, again...
Yeah, sorry, I'm just wondering whether you need subsection 3 to achieve that result. Because subsection 10 says, where amount is deducted or withheld pursuant to subsection 1, then shall, upon the amount being so deducted, so that seems to give you the timing, be deemed to have paid the same.
Yeah, yeah.
And cease to be
I
liable.
probably don't need subsection 3, but I submit...
I suppose the receipt is just a sort of rather sort of metaphysical step between deduction and deemed payment.
Yes, yes.
Yeah. And it's clearly subject to subsection 10.
And my lords, my lady, interest runs generally under section 103. There's no suggestion this has no application to employees. Can I deal with section 99(1)? Section 99(1), just one point I want to make on it. Section 99(1) itself, notwithstanding any provision of this Act to the contrary. But my submission is not saying the other provisions of this Act are irrelevant. It's just, it doesn't provide, in other words, for a complete replacement for anything else in the Act. It's simply saying, this is, you must also take into account what we say here, regardless of what you see in the Act, elsewhere in the Act. And then the words my learned friend particularly relies on are 1A and 1B in 474. What I submit is, first of all, you have to read 1A and 1B in the light of section 99(1), notwithstanding any provision of this Act. Those words are not apt to exclude the rest of the Act, and therefore you should read 1A and 1B in the light of that. Secondly, 1A and 1B are dealing with questions as between the employer and the revenue about withholding. Now that doesn't tell you anything about whether or not the employee has a parallel liability of his own to the extent that the employer doesn't discharge it under the PAYE system. And the third point I make is this: these are all quite specific, sort of little separate questions, which might naturally arise in the course of a continuing employment contract. And they don't deal with the position when, for instance, an employee makes a return, which you can have under section 77, nor do they deal with, nor do they expressly at least, provide any power for additional assessments to be made. So there's not a complete overlap. And on the contrary, what appears to happen is there's a dispute between the board and the employer about certain matters. The board then gives an opinion as to what the employer should be doing, and that's it. So there's no what you might call provision for the board, the revenue, 3 years later to say, well, I'm going to investigate you, the employer. It's the investigation specifically. This is just what you might call dealing with specific questions. It's not dealing with additional assessments or anything of that sort at all.
In many ways, it's a sort of crystallization machinery that if the employer under section 99(1) effectively is saying, well, I'm not sure how much I should deduct because
Yes.
I'm not sure this is an emolument, or I say it isn't an emolument.
Yeah.
And then 1A and 1B provide a mechanism for resolving that, so that that lack of clarity about the employer's obligation is resolved and their obligation becomes crystallized, I think, by the notice under 1B A.
Yes. Subject to the right of appeal, yes.
Yeah, of course. Yeah.
Before these provisions, 1A, 1B, 1C, 1D, before they were inserted, was there just nothing in this about this matter?
Very briefly, my lady, I have had a look at this. There's a supplementary bundle. I can deal with it in 5 minutes just to show what the history of these provisions is.
Well, if
See
you
how they
could
got
point
there.
us to where it is and maybe summarise in 2 sentences.
Yes. Well, the original Act had no such provision.
What? Nothing in... Does it have 99.1?
No, didn't even have that, no.
Sorry?
Didn't even have that. The original Act was passed in 1938. No. There was an Act which introduced an amendment in 1958, which is in the supplementary bundle. And I can give you the reference. It's at page 1028, I think, supplementary bundle, which basically introduces an earlier version of section 99(1).
You say a supplementary bundle. I don't seem to have such a bundle. And did it come in by email? I'm looking at our folder.
So there is a supplementary bundle with authorities tagged onto this one.
Yes, it's in the
Hence
main
page
bundle.
Oh, it's in the main
128.
one. I'm so sorry. Right.
So 1958, we get the earlier version of section 99.1.
Yes, 99(1).
Was all the machinery and regulations at that stage?
You mean elsewhere?
Well, no, I mean, where then was the machinery we now see in 1A, 1B, 1C, and 1D?
You had a sort of equivalent to 1A, but not absolutely. What I can do, perhaps I can cut it short, because there is one useful, I may say, provision, which is at page 1043, which shows you what the law, how the law stood in, either in 1990 or 1980, it's not totally clear, but this is a revised laws, which had all the various updates, and you can see how things stood at page 1043, how they stood at it looks like as in 1983, when you took into account all the amendments. And if you look at 1043, you have section 98. That's not so relevant for the moment. Section 99(1) gives you the original version, more or less, of what was introduced in 1958.
Yes.
And that's at 1044. You don't have the full, as it were, plethora of 1B, 1C and 1D. You haven't got that. But you do have the provision, slightly differently worded in section 99(1), about any question arising. So you had a rather lesser version of what we now have in 1980. And then if at page 1043, sorry, 1052, you have an act, begins at 1048 in 2000, which brings in the slightly altered version of section 99 at 1052.
Plus 1A.
Yeah, plus 1A. But not 1B, 1C and 1D.
And they all just creep in later.
And then they creep in, so to speak, in section 1062, or rather 1063, in 2004. So it's 1063 to 1064. So that's the gradual history of the insertions of 1A, 1B, 1C, 1D. And the point we make is, well, it's difficult to suppose that these gradual insertions were intended to somehow fundamentally to alter the structure of the previous, of the original Act, or at least of the original alterations back in 1958.
I mean, this looks just like machinery for determining, a quicker machinery for determining disputes, because
Yes.
after all, emoluments was defined all along in section 100.
Yes,
And presumably there was a rather more cumbersome machinery which would resolve a dispute at that stage. And maybe just a full appeal to the tax appeal board. I don't know, but
yes. I'm
I
not
mean, there
sure
must have
about-
been a way of resolving that dispute.
Well, all I can say is, if one looks at the position at 1980, there doesn't seem to be one. And it may be precisely because there wasn't one that
Maybe.
they actually
Or
put money in.
I mean, there's a sort of machinery in the 1958 version you showed us at 1044, section 99(1), because it contemplates a question arising whether emoluments are or are not emoluments, and certain questions about allowances, and it says such questions shall be determined by the board, subject to provisions of this act relating to appeals. So
it might be.
it's not actually not fundamentally different. One might think it's a slightly more kind of regulated way of doing that we have in 1A and following.
Yes. But anyway, my lords, I submit I don't need to go into the history, but we do say it is an odd idea that, on the face of it, the provisions my learned friend relies on carry as much weight as he says. Can I very briefly deal with one or two other points made by my learned friend? The first point he makes, or one of the points he makes, is a large amount of interest is clocked up in the meantime, and that's unfair. Well, my lord, my lady, I accept a large amount of interest that has clocked up. It was, however, the appellant's choice to pursue a preliminary issue. I mean, in one sense, what could have happened in this case is you simply challenged the assessment to court. You say, never mind about whether I'm liable or not. I'm not liable anyway for these things, whether or not you can come to me. But he's taken, if you like, the sort of the high ground and taken a preliminary issue, which unfortunately has had the consequence of interest going up.
Is there some mechanism for paying in, but reserving your right to challenge the assessment?
My lord, I don't know, to be honest. I don't know. But it's difficult to see why you couldn't at least offer to do so, and how that could stop. If you had done that, how interest could properly be chargeable in any event.
Yes, thank you.
In my learned friend's case, he says if the revenue is right, this allows for double recovery, effectively. Well, we say that's not right. There's no doubt that if the employer pays or withholds, then there is nothing, the relevant amount of tax, then there's nothing for the employee to pay. Of course, it is possible that the employee pays, let us say, if we're successful in these ultimate proceedings. The answer then would be if the employee pays, then there would be then the whole premise of the employer's liability would disappear, because the premise of the employer's liability is that the employee is still chargeable, was chargeable to tax. And one couldn't construe the act sensibly to say that the revenue could happily get the money off both. That would be an absurd construction. My learned friend says that our construction places an impossible and unfair burden upon the employee because it requires the employee to challenge the employer. Well, there is no difficulty if the employee knows, or ought reasonably to know, that the amount that's been deducted, or rather that he's been paid far too much. If I know that my after-tax income is supposed to be £1,000 a month and my employer is happily paying me £3,000, let's say £1,400 a month, I know that. It's not a great burden on the employee, at least where it's fairly obvious, to require him to challenge the employer. But anyway, we say in any event, that sort of consideration cannot affect the proper construction of the Act. And if there were any difficulties or unfairness against the employee, then as I said, there are ways of dealing with that in any event. Next, my learned friend says that the revenues construction penalises the employee for the employer's failures. Well, that assumes the same point that the employee doesn't know or shouldn't reasonably realise that the employer's gone wrong. And next, my learned friend says there would be an inconsistency in the appeal process because effectively you could have two appeal processes going on at once, I understand it, or one would follow the other. Well, in my submission, the answer to any possible inconsistency in the appeal processes would be for the employer or the employee to ensure that their cases were heard together. It's difficult to imagine in real life that if the employer is being as it were, attacked by the revenue, the employer won't inform the employee, and vice versa.
Can you just remind us which is the interest provision?
103.
Thank you.
My learned friend also runs the alternative argument that even if the employee does bear a liability, it is, so to speak, only a secondary liability, and that what the revenue must do is go after the employer first. My short answer to that is that's just not in the Act. That's not what it says. That might be a discretionary consideration, which might be something which one could challenge on judicial review, but it's certainly not part of the law. And finally, just on the procedure.
Well, sorry, just on that, I mean, I wonder whether it's even consistent with Unilever itself, which said that you didn't have to have an assessment of the employee before you get into the...
Absolutely. I mean, we say there is a separate system, that's that. But again, one possibly could posit certain situations when it's just unfair or it creates an unfairness. But the answer to that would be that's for judicial review. It doesn't go to the proper construction of the Act, and that is the only issue before you. And as to the procedural point, can I just mention this? If you go to page 576, when I said, is it open to the revenue to run the arguments we're now running? 576 is the Tax Appeal Board rules at 7.1 is the provision for appeals to the Tax Appeal Board, self-explanatory. And then section 7.5 provides for the appellant's notice and power in the board to allow the appellant to run other grounds at the hearing if it's reasonable to do so, essentially. Then you'll see 577, section 8, subsection 7. The decision of the appeal board is final on a question of fact, but subject to section 9, an appeal shall on a question of law to the Court of Appeal. And, my lords, I say that's entirely open. And then section 9.5. 578, the Court of Appeal shall hear and determine any question or questions of law arising on the case, and so forth. We then go to the regulations my learned friend relies on. The first is Regulation 24.591. That provides for what's to be in a notice of appeal. And then Regulation, page 592. It's Regulation 27. And 28.
What's this all going to?
This goes to whether we, the respondent, are entitled to run the arguments on section 89. What's being said is that we're going outside what was argued in front of the...
As I understand it, I think you told us earlier you did run it.
Yeah.
We did indeed, yes. But it maybe all I need to do is to give you the reference for that, is page 47 of the electronic bundle.
And, I mean, certainly reading the decision of the board, they specifically set out section 89 where they set out all the relevant provisions for their determination. Section 70, whatever it was, only comes in right at the end. 79.7 comes in much later.
Page 49, I think, the electronic bundle, section 9 is the argument we were relying on.
Where's this paragraph?
49 of the electronic bundle.
Electronic?
Bundle, page 49.
49.
Yeah,
49.
paragraph 27.
27 refers
Yes, I
to provisions of Section 80.
I mean, the paradox is, funny enough, we are reverting to exactly the arguments we went below at first, before the Tax Appeal Board.
Yeah.
And you know what happened subsequently. So in my submission, there's nothing in the procedural point. As far as the relief is concerned, obviously we say you should simply dismiss the appeal if we're correct. If we're wrong, then, my lords, my lady, I apprehend that the well, it's not quite clear because an assessment has been made. If we're wrong in saying we were entitled to make an assessment directly on the employee, that part of the assessment which is referable to his employment income, I would accept, should be quashed. It's not 100% clear to me whether all of it is necessarily referable to his employment income. That's all I would say. I don't know if is that correct? It does seem to me, reading I think pages 4 and 5 of the bundle, that there may be some question mark as to whether all of it is referable to his employment income. But certainly that which is referable to his employment income would have to be quashed, but not that which is not referable to his employment income.
So just to make a point on interest, it's just to draw attention to page 478, section 1031.
Yes.
One thing that was going through my mind is that the employee may, in complete good faith, think that something he has received from the employer does not qualify as an emolument, but it transpires later that it does, so that tax is underpaid. And I wonder whether the legislation might act unfairly in that situation if, despite making an innocent mistake, the 20% interest was payable. But I see at the end of section 103(1), the board has a discretion on being satisfied the difference is not a result from the taxpayer's own default. Yeah, so I just wanted to make sure that I'd understood that that's the way it works.
So he's, yes, only if he's at fault. But, well, if he's at fault, yes, but if he's not at fault, then they can say, well, we're not going to charge you for that because I understand why you made the mistake.
Yeah, okay, thank you.
My lords, my lady, those are my submissions unless there's anything further.
Can I just ask one question? I don't know whether it's right to ask you this or the appellants, but if we go to page 11 to the appellant's return,
yes,
income tax return, some of the, I'm afraid some of the print is a bit indistinct, but under the section towards the foot of the page, tax computation section,
yes,
item 1 is income from employment as per TD4 enclosed, 293,000. And then item 3 reads as if it's, best I can do, is pensions from sources within
stroke outside
T&T, Trinidad and Tobago. That was 1,087,000 odd, therefore making a total emolument income in line 4 of 1,380,000. And then go to page 12, there's some deductions, and I think in about line 5 we arrive at assessable income of 1,260,000.
yes,
Chargeable income, the same amount, that's further down the page. And then the tax on chargeable income is 315,000. And we see that income tax has been deducted, PAYE,
yes,
of 125,000,
total pre,
leaving a balance payable of 189,000 by the appellant personally.
yes,
That presumably, I mean that. So this is not, although we were told that this was his only income, actually he seems to have a significant pension income, which means that there is a significant amount, even on this return, of tax payable by him, which has not been the subject of deduction because it wasn't an emolument. Is that, am I reading this correctly? Do you think I'm
not sure. I think I...
Yes, I didn't know.
Yes.
I mean, it doesn't make a huge difference, except that it might make a difference as to which of the various sections we were looking at actually applies to this return. I mean, on these figures, he should have been making quarterly payments, I think, through the year. If I'm right about this.
Yes.
Well, it doesn't appear to. There certainly seems to be a total prepayment, so 125,000.
Well, those are the deductions.
Yes.
Yes.
And then entire balance, enter balance pair is 189,000.
Yes.
So he's got to pay another 100.
He's got to pay 100. He may have, anyway. That's yes. Right. Well, thank you very much.
Thank you very much, Mr. Knox. Mr. Ratz, thank you. You've got about 15 minutes for your reply.
Thank you, my lords and my lady. Prior to this, we'd always had a division of labour in which my learned friend, my learned junior, was planning to take the reply. But I just wanted to just do a couple of things because it's a background that, because I've been involved, I would be better at addressing than my colleague. So, in respect of this, there really was an application at the very beginning and a preliminary point dealing with, simply put, the emolument income. And you could see what is the subject of this particular application. It's at page 9 of the electronic bundle. So it's really what the revenue spoke to in terms of being benefits in kind. It was that specifically that was the subject of this application. It was to say that given it is benefits in kind that is purely a matter of emoluments, those ought to have been subject to section 99(1)A and the 99(1)B procedure.
It refers there to commissions being deposited in an account.
No, well, the thing is, it's the revenue's position that those items were benefits in kind. It's not the revenue's position that those were something else. It's their position that those funds are benefits in kind.
We don't need to make any ruling on that at all. No.
Yeah.
Okay.
And that's actually one of the other major overriding points here in terms of it being a so-called under-declaration of a significant sum and so on. I mean, it was a preliminary point. I know many years have passed and so on, but these were the issues that would be ventilated at trial, and it's really, I would probably even say, inappropriate to suggest that there's been a finding of an under-declaration, and that's not the case.
Yeah, well, at the end of the day, we have to interpret the statute on the basis that there may be some cases of under-declaration, there may not. We don't have to make any ruling about Mr. Monteil's affairs.
Right. Yes, so I just wanted to just be specific on those points. And again, in terms of, I said, we have 15 minutes, and my learned junior will be speaking to this. But the other issue here is there are two issues. So I will just deal with the first issue, which is what my primary submission was on. My friend has somewhat addressed the issues of 99(1)A and 1B, but not adequately, I would submit, because the issue from the provisions that we've shown is that the 99(1)A and 1B provisions are incorporated into Section 89. And that's what we're saying. So for my friend to just say 89, let's just say he could do it, didn't address whether the 99(1)A and 1B procedure were adequately, were even utilized, and the impact of that in Section 89 to the extent that they are provided for in the language which I've pointed to out before. And I don't want to go over that at depth. So I just want to just make the point that we still have two issues, and on the first issue, there has been limited submissions on that in response from my learned friend. But as I said, in the interest of time, I shall let my learned junior, Mr. Gale, address the board, if he may.
Thank you very much. Mr. Gale.
My lord, my lady, thank you. I'll be as quick as I can, in the amount of time that's there. My lord, Lord Paul asked about under declaration, and make the point that here the board doesn't need to come to any view as to whether or not there was in fact an declaration. That's certainly correct. Mr. Monteil's point in respect of box 1 specifically, however, is that when one talks about what an under-declaration means in respect of box 1, really the employee's function is to report what is in the TD4 certificates. So the TD4 certificates say a million has been deducted, and the employee simply reports that. So the question is, what does it mean to under-declare in respect of box 1? I fully accept that it's possible for an employee to under-declare in respect of other income, and perhaps even other emolument income, such as pensions income, going to my Lord Richard's points. But in respect of box 1, the employee's, I won't say statutory obligation, but the direction which the revenue itself gives is insert the amount as per TD4s. So we say that reflects the fact that the employee is not estimating their income from employment as such. However, it is possible when the employee does their box 1 and the other boxes in their income tax return, they realize, for example, that they fall into a higher bracket of tax, and therefore more tax is chargeable or due than their employer has deducted, and so they may then fall into section 79.6 or 79.7, depending on whether there's other forms of whether or not it's fully emolument income or not. That's the point of under-declaration. Moving on to windfall, my learned friend makes the point, effectively, if I've understood his submission correctly, that the employer's liability under Section 99.4 would somehow fall away, because the premise of the employer's liability is that the employee himself is liable to tax. We can see that's actually wrong from Section 99.4 itself, insofar as it provides that the employer will be liable for an amount equal to $40 or 25% if the board orders otherwise. Now, the employee has never been responsible for that amount, so you can immediately see that the employer's liability doesn't always match the liability of the employee. Apologies, my lords, my lady, my technology failed me just as I was going through. So in our respectful submission, there really is nothing in Section 99 or elsewhere which relieves the employer from the obligations under Section 99.4. And indeed, that employer has committed a criminal offence. So it's not as though the criminal offence suddenly just disappears.
So you're dealing with a situation where the employee has directly paid what he owes to the revenue, and you're looking for some provision that lets the employer off paying that sum over again.
Exactly, and there is no such provision. And that's the point. Really, this is one of the practical problems in my learned friend's interpretation. And in fact, my lady, if we look at Section 99.2, which is Electronic Bundle 475, what this says, in short, is that when tax is deducted under subsection 1, so this is not the subsection 4 scenario, this is the ordinary subsection 1 scenario, that tax, when it's paid to the board, effectively the board will provide a receipt, and when that receipt is provided, then there will be a good and sufficient discharge of the liability of such person, i.e. the employer. So the employer gets their receipt, and then the liability is, or the receipt is issued, I suppose, and then the liability is discharged. So, for my learned friend to suggest that the possibility of a double recovery or a windfall, however one wants to characterize it, to suggest that simply doesn't arise, in my respectful submission, that can't be reconciled with subsection 2. It can't be reconciled with subsection 4. And in any event, what he really needs to do is find a provision somewhere in the Act which says, okay, now that we have the money from the employee, the employer's off the hook, and you can't find that. And it's just another hint at the nature of this scheme. That That's the windfall point. The administrative burden point, I note that my learned friend doesn't really, in my respectful submission, address the point about the information asymmetry which exists between employees and employers. So my learned friend Mr. Stats talked about the example of Unilever. How does the employee know what the benefits in kind are? We have to remember, in my respectful submission, that payee is intended to create an efficient system for the collection of tax. That's the policy, and I think my learned friend himself acknowledges that in his case. What is efficient about getting employees across the country to go and test whether or not their employers have got it right on benefits in kind, and to seek information, for example, as to the value of leases and lease payments? And I just note, I don't have time to take you to this, but in paragraph 87 of Unilever, electronic bundle 988, Justice of Appeal Raj Kumar noted essentially that it makes sense to put the onus on the employer because the employer has to make judgment calls which affect a number of employees. So, for example, I've provided 10 cars, and whatever decision I take on this is going to affect all 10 of these people. So it makes sense, put the onus on the employer, give the revenue its one party to deal with, i.e. the employer, and the employer will make uniform decisions across the board. That is efficient collection of tax, and that is the scheme which Mr. Monteil says exists. In terms of interest, which is closely related to this, my learned friend effectively said Section 103 applies generally across the board. And there's a couple points on this. Firstly, if interest applies generally across the board, that means interest is ticking under 99.4 and it's simultaneously ticking under Section 103. And this feeds into the double recovery point. It's ticking on the employee who according to my learned friend, ought to have realized that the employer had under-deducted tax, ought to have presumably inserted an alternative figure into box 1 despite the revenue's instructions, and then ought to have, I guess, on the back of that, paid the money. Because he didn't do all of those things, because he followed the revenue's instructions, interest starts ticking against the employee. At the same time, Section 99.4 makes quite clear that interest is ticking against the employer who's committed a criminal offence. So we've got two sets of interest ticking, which again is a signal that something is wrong here. And my learned friend seems to suggest, well, Mr. Monteil took the high ground, he could have paid this, but I'm not sure that's fair on the facts. The first notice of assessment, I believe, is on page 248, and you will note there that Mr. Monteil, when the first time he gets this notice of assessment, says, you owe us $8 million of interest today, because you should have, 6 years ago, gone through the process I've just described, you should have paid this amount. So it's not as though he said, here is a dispute and I'm going to fight this for 6 years. No, there's a dispute here. We disagree with what your employer did. We disagree with the fact that you didn't challenge your employer and do something different. Therefore, pay $8 million of interest. The other 31 million of interest or so is the cost of fighting this appeal effectively. And yes, to my Lord Sale's point, it's possible for the revenue to exercise a discretion to relieve the employee. But the question is, well, what is the rational scheme? What is the workable scheme here? Or at least what is the more rational scheme? And in my respectful submission, the more rational scheme is one where the employee isn't on the hook in this way and effectively needs, to use somewhat pejorative language, which I apologize, it essentially means the pardon of the revenue for their employer's mistake. We say that isn't the rational scheme, that isn't the workable scheme. When it comes to, and I'm going to move on, the insolvency protections, before I jump into that, we accept fully that there are outlier cases, as Mr. Add said. We are not saying that the insolvency protections mean that there are never going to be cases where the revenue is out of pocket. We accept that. What we're saying is these are outlier cases if you act quickly, and that there are protections. I accept the protection that my learned friend identified in 1995. It's an additional protection to what exists in the Bankruptcy and Insolvency Act. And I think the question was asked, well, what is the provision in the Bankruptcy and Insolvency Act which gives preferential treatment to tax debts? And the answer is section 127F.
Section what?
127F.
And that's just a standard priority for
Standard priority.
state debts.
Yeah.
Or was it particularly revenue debts? Is it revenue debt or more widely?
Taxes is the language that's used. Yeah, taxes. So what we're saying is essentially the scale of the problem that my learned friend is putting forth is being blown out of proportion. On the other hand, the problems which we are identifying, we say in our respectful submission, they're not being adequately addressed by the other side. And ultimately, no one is saying that there's a perfect scheme here. So the question, in a sense, is, well, which scheme is better, or at least which scheme accords with the policy of the Act? And the policy of the Act is efficient collection of tax. And for the reasons I've given, we say our scheme is the one which best accords with that. Very quickly, I can't go through all the provisions that my learned friend refers to in his case, or even all of those which he referred to in his oral argument. I would say as a general point, when the board rereads these provisions, there's a distinction between a provision which speaks to when someone has a payment obligation and a provision which speaks to what happens if you have a payment obligation. In my respectful submission, these provisions, such as interest, are saying if you have a payment obligation, then you must do X or the revenue can do Y. They're not speaking to who falls within the anterior question of whether or not it is employees or employers. And again, I can't go through them, but you'll see language such as when a payment is due. Well, whether or not a payment is due is what we're here arguing now. And that's what my learned friend needs to show. Just because it says any person doesn't mean that any person falls into Section 103. That makes no sense. First, you need to establish the anterior payment obligation. And so I would invite the board to keep that distinction in mind when it reads those sections. He did take you to 110, and I'll just address that briefly. So 110 is at electronic bundle 483. And this is essentially the provision which talks about having a certificate before in the magistrates, in proceedings of the magistrates. And he's right to say that it's assumed in some of these provisions that the employee can end up effectively on the other side of these recovery provisions. And we fully accept that because of Section 79.6 and 79.7. So when my learned friend said, if I heard him correctly, when he suggested that we were, that our case was that Section 99 is a complete and comprehensive code, that's not our case. Section 79.6 and 7 exists. And so if you keep that in mind when you read these provisions, it explains to the extent that they apply to employees, well, then that must be what it is about. But indeed, very few of them mention employees at all. Subsection 3 itself, I think my learned friend respectfully has put too much weight on that section. It effectively says that a written statement can be used as evidence for the amount that the employee has actually received. We're not saying that employees can't end up in provisions where they owe tax. So for example, this may be relevant if you're looking at an employee's tax liability and the employee wants to show that they have three types of liability. One of them is employment liability, and they say, well, I don't fall into that bracket because I only make $1,000 a month. In that context, the certificate is relevant, but it doesn't mean that the sole focus of those proceedings is emolument income which has been under-deducted. It's essentially what my learned friend is saying. Let's see if there's any more points, and I appreciate I've gone through them at quite a clip. Just on Section 83 and 89, the reality is, my lords, my lady, that whether or not an assessment took place and whether or not an additional assessment took place is, in our respectful submission, a question of mixed fact and law. this isn't simply, the revenue may have pleaded that it accepted the return, but the question is, well, did it in fact do an assessment at that time? Was there an auditor who did it? And then did they do an additional assessment later? And what caused them to do an additional assessment? Those are all issues of fact for trial. So I would respectfully submit that it would be wrong for the board to effectively preempt that by saying, oh, this was a Section 89 case. We're not there. This is a preliminary issue which says, even if it is a Section 89 case, we say Section 99 1A and 1B trump. But if we're wrong about that, then we'll have an argument, unfortunately, about whether or not there was an assessment or an additional assessment. And the board will note that there's only one notice of assessment in the bundle. So it will be for the other side to show that this was in fact an additional assessment. And they'll have to show that, notwithstanding that their pleaded case says that it was the opposite, it was a Section 83 assessment. But those are not issues you need to determine. The point is, those are issues for trial. So I think the board can proceed on the hypothetical that this is a Section 89 assessment, and then we'll see where the cards fall. But the board shouldn't preempt the trial judge's finding of fact and law on what the nature of this assessment was. Unless there's anything else I can assist you with, those are my submissions.
Thank you very much, Mr. Gill.
Can I just mention that the Bankruptcy Act, the relevant provision, Section 127F, I've only just looked at it, but it seems to apply to bankrupts as opposed to insolvent companies, and it applies only for the 1 year's worth of tax. I don't know whether it might be helpful if your lordships would be interested, just a very short note on what actually the Act says.
Yes, well, if within 7 days you could produce a note which the appellants have been able to comment on and hopefully agree, that would be helpful.
I'm obliged, my lord. Yeah.
At one point, while you're on your feet, Mr. Knox, it's being said that we should simply decide the matter on the hypothesis that an additional assessment under Section 89 has been made. Are you content that that's the correct approach?
Yes, I mean, I think that is, our approach is indeed that the additional assessment was made under Section 89. That's
yes, yeah, that is your approach, but what I'm being told is that may be a disputed fact.
Oh, I see. In that case, I'm prepared to treat it as a hypothesis, as concerns your lordships, without prejudice, obviously, to make whatever submissions are appropriate if and when the matter goes back.
Thank you. That's very helpful. Thank you. Well, the board is very grateful to council for their submissions in this case, and will take time to consider what is its appropriate judgment. The board will now adjourn.